Ladies and gentlemen, thank you for joining us today and welcome to our firm's Investing in India program and the 13th webinar in this series. My name is Prasenjit Chakravarti and I am a partner in Khetan's corporate and commercial practice group. I would like to extend a very warm welcome to every one of you wherever you are around the world. Investing in India is our webinar program curated especially for existing and prospective foreign investors in India and their advisors to deepen the understanding of key issues involving doing business in India. Over time, the series aims to cover the full range of topics that matter to our target audience. Today's session turns to one of the most consequential reforms of the last decade, the Insolvency and Bankruptcy Code 2016, commonly known as the IBC. The IBC has reshaped the way capital behaves in India. It has strengthened creditors' rights, revitalized distressed asset acquisition and resolution, and brought India significantly closer to global best practices in insolvency law. At the same time, legal, procedural, and enforcement challenges continue to evolve, and investors need clarity on how to assess risk, price and structure acquisitions, and maximize recovery. In a moment, our speaker today, Siddharth, will unpack how the code works in practice and what it means for you as international financial and strategic investors, where the real opportunities lie and where the tripwires are. On this slide is the agenda for today's program. If you do have any questions, please submit them using the facility provided in the webinar portal. If we are not able to cover all your questions during the webinar, we will respond offline by email after the webinar. Also, please note that a copy of the presentation, summary notes, and the recording of this webinar will be sent to you after the webinar as a matter of course. Let me now introduce our speaker for today. All registered participants should have already received an email with the resume of our speaker and myself. So I will keep the introductions brief. Our presenter today is Dr. Siddharth Srivastava. Siddharth is a partner with the Restructuring and Insolvency Practice Group. So I would now like to invite Siddharth to present on this very exciting topic.
Thank you so much, Prasenjit, for the introduction, and thank you everyone for joining this webinar on the Indian Insolvency Code. Now, before we move on to the details or detailed aspect of the Indian Insolvency Code, or IBC as we call it, let's look at the overview of this presentation. I wanted to sort of give you a quick spiel as to what we are planning to cover as a part of this presentation. In terms of the overview, if you can move on to the overview slide, please. In terms of the overview, we will start off with objective applicability and scheme of the code. The idea is to, of course, take everyone through why was the code promulgated in the first place, who all it is applicable to, what is the scheme of the code. We'll then move on to the relevant stakeholders. Who are the relevant stakeholders who play a key role in terms of making IBC happen or making it a success. We'll move on also then to the IBC story so far. I wanted to give you a quick update on how many CIRPs has been admitted so far, how many have met with resolution, if any CIRP process has resulted into liquidation, and so on and so forth, some data points. We'll then move on to the meat of the presentation, which is the life cycle of CIRP, which is corporate insolvency resolution process. The idea is to take you through the entire life cycle of CIRP and tell you what are the timelines which are involved, which stakeholders plays what role during the CIRP process. We'll then move on to the roles and responsibilities of resolution professional, because of course they're a very, very key player in the insolvency process. We'll then move on to committee of creditors, what role the committee of creditors or the lenders, financial institutions, banks, NBFCs play in terms of overseeing the process. And we'll also then touch upon cross-border insolvency very briefly, from the perspective as to where we are, what is the law applicable, and what else is needed in terms of cross-border insolvency, following it up with key considerations for investors. When an investor is looking to acquire stressed assets in India, what are the criterias which it needs to look into? What are the diligence items which needs to be carefully crafted? How do we address the diligence finding? How do we stitch up the resolution plan? And that would be followed by a case study of three large insolvency cases which were a part of Dirty Dozen, which was the RBI list of Dirty Dozen. What happened to these cases? Did they end up in liquidation, resolution, or they're still under implementation? With this thought and with this overview, we'll move on to the first slide of the presentation, which is the objective of the code. In terms of objective, one of the core objective of the Insolvency and Bankruptcy Code was to consolidate the laws relating to insolvency resolution of corporate persons, partnership firms, and individuals. The other objective was to ensure maximization of value of assets and resolution in a time-bound manner, while ensuring the going concern status of corporate persons. Now, this objective of going concern status of corporate person is very, very important. This is what differentiate the insolvency code with other recovery statutes like SARFAC or the RDDB Act, because the other statutes primarily focus on recovery of debt by the lenders, while IBC was brought into force to make sure that the corporate debtor or the company or the borrower runs as a going concern while ensuring maximum recovery for stakeholders. So it tends to achieve a larger purpose than just recovery of debt of the stakeholders or the lenders. The other objective is to promote availability of credit and balance the interest of all stakeholders, and also to reduce multiplicity of forums. As you would know, some of you would know that there would, before the IBC came into force, there were multiple forums for resolution of debt, for taking the company, for recovering the debt. What IBC has done, because it's a unified law which covers corporate persons, partnership firms, and individuals, there is one common forum which has been made, which is the NCLT, National Company Law Tribunal, which will hear all the cases pertaining to the insolvency process, and therefore it has reduces the multiplicity while making it more time efficient. With this, we will move on to the other part of the presentation, which is the applicability. It is equally important to understand who all the code is applicable on. So we'll move on to the next slide for this. In terms of applicability of the code, it is applicable on any company which is incorporated under the Companies Act, which is the Indian Companies Act 2013-1956, or any other company governed by any special act for the time being in force. The code is also applicable to limited liability partnership and any body incorporated under any law as the central government by notification may specify. Not only this, as I said before, the code is also applicable to personal guarantors to corporate debtors. Now, these personal guarantors are mostly the promoters or the individual promoters who have given personal guarantees for a loan taken by the corporate debtor or the borrower, and the code squarely applies to them in terms of taking them into the insolvency or the bankruptcy process. And not only this, the code also envisages insolvency bankruptcy process for individuals which are other than these personal guarantors to corporate debtor and other partnership firms and proprietorship firms besides the LLP, but provisions with respect to them are still to be notified. They're yet to be notified. The code does provide for detailed mechanisms for insolvency, but for individuals and partnership firms and proprietorship firms, the code is yet to come into force. And of course, that should be notified in due course. With this, after having understood the applicability, it is important to then move on to the next slide, which talks about the institutional framework of the code is concerned. And we'll move on to the next slide. In terms of institutional framework, it is the NCLT, which is the National Company Law Tribunal, or NCLAT, which is the Appellate Tribunal. They play a very important role. NCLT is the adjudicating authority, which is like a court or a tribunal for corporate insolvency and for personal guarantors, as I said before. What it does, it admits cases, approves and rejects the resolution plan and orders for liquidation. Also, NCLT is required to adjudicate any dispute between the parties who are undergoing the CIRP process during the course of the CIRP or the liquidation. NCLT, as I said, is an appellate forum which here appeals against the NCLT order under IBC. The other important player or the regulator, I would say, is the Insolvency and Bankruptcy Board of India. It is actually the regulator for insolvency professionals, insolvency professional agencies, and information utilities. The job of the IBBI, amongst other, and it is performing a very, very important job, is to issue regulation, monitor the conduct, and enforce discipline, especially among the resolution professionals. We'll move on to the next slide, which again is talking about the institutional framework. And again, the most important players or stakeholders, if you can call, are the resolution professionals or liquidators and committee of creditors. Resolution professionals or insolvency professionals, as you call them, they are very, very important in terms of the IBC process. They're not technically a stakeholder, but they are court-appointed officers who are supposed to take control of the debtor during CIRP or liquidation and run the business as a going concern, manage the process, collate claims, and run the sale process, and ensure that they ask for submission of plans and they receive bids and then pass it on to the COC for their consideration. So insolvency professionals play a very important role. If the company for any reason is not being able to revive under the CIRP process, then it's sent for liquidation, where these liquidators are appointed who again perform a very important job of ensuring value maximization for all these stakeholders. Committee of creditors, of course, and we will in the course of the presentation give you the details of detailed roles of COC, committee of creditors, and insolvency professionals as well. But COC is composed mainly of financial creditors who vote in proportion to their exposure. They approve key actions and select the resolution plan when it is submitted by the prospective bidder. They apply their commercial wisdom, which is given high deference by the courts. COC has the absolute authority to apply commercial wisdom to select any particular plan which they think will give maximum value to all the stakeholders involved. So that basically wraps up the institutional framework. Now it's important to move on to the next slide, which talks about the scheme of the code. In terms of the scheme, the code is divided into 5 parts. Part 1, of course, is application and definitions. Part 2 is where, as I said, the meat of the code lies. It basically talks about the entire corporate insolvency resolution process and also the liquidation of corporate persons, which is most often used. Part 3 of the code talks about insolvency resolution and bankruptcy for individuals and partnership firm. As I said before, some of this is yet to come into force. Some of this has already come into force, especially in context of personal guarantors to corporate debtors. Part 5 of the code regulates the insolvency professional agencies, and information utilities. Part 5 is a miscellaneous section, which amongst other things talks about cross-border insolvency. There are enabling sections of cross-border insolvency, and also specifies the overriding effect of the code with a view that if there's any inconsistency between any other statute or IBC, the provisions of IBC will prevail. This is to ensure that IBC does really work and doesn't get involved in legal interpretations and legal tangles, and the purpose of the code is achieved. We'll move on to the next slide in terms of explaining who are the relevant stakeholders. So the relevant stakeholders have been divided into 3 buckets, as you can see. The existing stakeholders in context of a corporate debtor would be the promoter, the financial creditor, the operational creditor, which also includes workmen and employees and government and tax authorities. They are, of course, the existing stakeholders who are already there, who are invested in the company, and who have an exposure towards the company. And then once the insolvency is triggered, there comes the post-trigger participants. NCLT, of course, the National Company Law Tribunal or the adjudicating authority is a post-trigger participant. Resolution professional or insolvency professional or administrator, whatever you want to call them, all of them, of course, mean the same. They are post-trigger participants, COC, and the liquidator in case the company goes into liquidation. In terms of key restructuring catalyst, in this entire IBC ecosystem, the investors are very, very important, being a key restructuring catalyst, because these investors, whether they are strategic investors or financial investors, they are responsible for taking over a company and giving returns to the stakeholders. So they play a very important role. Another catalyst, important catalyst in terms of the IBC process, are the new money financer, the institutions or the outfits who provide interim finance to the company, because mostly in many cases we have seen that the corporate debtor does not have money to run its operations, in which case these new money financiers come in, they provide interim finance and get super priority status in terms of their repayment. So therefore, these are the relevant stakeholders in terms of IBC. We'll move on to the next slide, which talks about data points in terms of IBC story so far. Uh, Again, it's important to give you a quick spiel on how, from the data perspective, IBC has fared. If you can see the total admitted corporate insolvency resolution process, the total cases which have been admitted right now is 8659. This data is subject to further updation. Uh, Out of these, 15% plans have been approved, which is great. 16% of these cases have been closed on appeal or have been settled. 14% have been withdrawn under the provisions of Section 12A, which basically says that if the COC by a 90% vote decides to withdraw a particular CIRP, it can, subject to following certain conditions. And 33% has been liquidated, while 22% are still ongoing. When we say that it has been liquidated, it does not necessarily mean that the stakeholders haven't got their returns. During the liquidation process also, the IBC provides for a detailed mechanism which also ensures recovery to stakeholders. We'll move on to the next slide, where we talk about what sectors have seen the maximum amount of insolvency. So in terms of sectoral distribution of CIRP admission, uh, we have seen the maximum amount of CIRP in the manufacturing sector. 37% is what the data shows, followed by real estate, which is 22%, followed by construction, 12%, 10% in wholesale and retail trade, and then 2 to 3% in hotels, electricity, and transport, while 11% is others. This basically shows the spread in terms of what sectors are fairly active, and we can perhaps go into the details separately as to why these sectors are seeing the maximum amount of CIRP. But with this, we just want to move on to the next section of the presentation, which basically talks about, and we can move to the next slide for this, which talks about who can trigger IBC. It is very important that when we are talking about the Indian Insolvency and Bankruptcy Code, it is important to understand who are the stakeholders who can trigger. So the insolvency can be triggered by three categories of stakeholders. One is the financial creditor, are basically banks, financial institutions, NBFCs, who have advanced debt against time value of money, or who have given loan, debentures, any outfit which has given receivable discounting, entered into forward sale purchase agreement, including the beneficiaries of corporate guarantees also. So if a corporate debtor has given, or if a company has given a corporate guarantee for the benefit of a particular bank or a financial institution, that guarantee also constitutes, upon invocation, a financial debt, and therefore the beneficiary of that guarantee can be a financial creditor. Operational creditors are primarily those creditors who provide goods and services in lieu of money. They include employees, workmen, and also government authorities. So government dues are covered within the ambit of operational creditors, and therefore they also have a right to initiate insolvency. The threshold for admission of applications filed by operational creditors is relatively higher, because the NCLT or the tribunal will check if there's a pre-existing dispute or not, because there could be smaller operational creditors also who would be filing. So therefore, the threshold is much higher. In context of financial creditors, it's very simple. There has to be a monetary threshold, and which is, by the way, applicable to all three stakeholders, of INR 1 crore, which is equivalent to USD roughly 111,000. If you cross that threshold, you make an application. There's a default of more than INR 1 crore. You can file an application and get it admitted. The corporate debtors themselves can also file an application after passing a special resolution and after meeting certain conditions, which is specified under the code. In all three cases, the monetary threshold of INR 1 crore or USD 111,000 roughly will apply, and therefore NCLT will have a look and then may choose to admit. a particular case under IBC. We'll move on to the next slide, which basically talks about the details of the CIRP process. What does how does the CIRP process look like? And if you can move to the next slide for that, I will give you a quick overview of the process which is envisaged. So as you can see, application, once it's admitted by NCLT, the CIRP starts. The moment CIRP starts, there's a moratorium which sets in, and moratorium is on the suits, existing suits, proceedings, judgments, court order. There's a standstill. There is a moratorium or a standstill on or an embargo rather on any sale of asset, disposal, encumbrance, or alienation by the corporate debtor. If any property of any owner is lying in the premises of the corporate debtor, there is a moratorium or an embargo on recovery of such property by that owner or lessor as well. Also, more importantly and most importantly, there is a clamp down on SARFAESI actions or the recovery actions by any of the creditor. If any creditor has already taken a recovery action, that there's a clamp down, there's a standstill on those recovery actions, because otherwise it would frustrate the very purpose of IBC. You can't revive the company if the creditors still have a right to enforce their security. So once moratorium sets in, parallelly, upon admission by NCLT, the powers of board is suspended. The existing board cannot exercise its power. The IRP, which is the interim resolution professional, which will then can be confirmed as the resolution professional or the administrator, replaces the existing management. It does and starts running the company. Then the IRP/RP invites claims and constitutes the COC. The committee of creditors, we will, again, as I said, we'll go into the details of the voting threshold and all, but primarily the committee of creditors comprise of financial creditors, except in certain cases. And of course, they will approve the resolution plan by a voting of 66%. They can also veto any actions, including related party transactions. So therefore, COC will be constituted. Eligible bidders then will be invited by the resolution by the resolution professional to submit their resolution plan or the bid. Once those resolution plan is received, the RP will evaluate the legality of the resolution plan, toss it over to COC. We'll give it to COC for its final decision on the resolution plan, whether they are agreeable with the resolution plan, they want to vote in favor or not. COC, by, as I said, by a 66% voting threshold, will either accept the resolution plan or reject the resolution plan. If COC approves the resolution plan by 66% threshold, then it goes to the NCLT for its final approval. NCLT in such a case most likely will check whether the procedural compliance has taken place or not, and generally would not interfere in the decision of the COC unless NCLT feels that the process has not been run properly or there are some other interest of the stakeholders. NCLT will approve that plan, and that once approved, that plan will be binding on all stakeholders. If not, then NCLT can also order the liquidation. Now, key points here to also understand is RP here is to run the CD as a corporate debtor as a going concern. Liquidation is not the first resort, it's the last resort. And on liquidation, again, right now the attempt is to sell the corporate debtor as a going concern and then resort to asset sale. So that's the process, and all this has to be done within 180 days, which could be extended up to 270 days, and then a further extension up to 330 days. It can further go beyond 330 days, but that would require permission of the NCLT. And the time period has been specifically mentioned to ensure that this entire process is completed within an efficient time period, so that the returns are maximized and recovery is it doesn't take much time. So after having explained the CIRP process in brief, we should move on to the next slide, where we should touch upon the roles and responsibilities of the resolution professionals. Much of it has already been covered during the course of this presentation, but just to give you a quick update on what the actual roles are. The resolution professional is supposed to collect all the information relating to assets, finances, and operations of the corporate debtor. It's supposed to collate claims, it's supposed to constitute the committee of creditors, take control of the assets of the corporate debtor, prepare an information memorandum, which is for the consumption of the prospective bidders, invite the prospective resolution applicants or the prospective bidders to submit the plan, and once received, present the resolution plan to COC for its approval. So it's a court-appointed officer who's supposed to run the entire process to ensure that plans are received and then it is further adjudicated or looked at by the COC and NCLT. With this, we should also talk about in the next slide about the roles of and powers of the Committee of Creditors and the constitution of Committee of Creditors. The constitution of Committee of Creditors is fairly simple. Financial creditors, typically banks, financial institutions, except related party financial creditors. Related party is a term which has been defined in the IBC. And if you fall within that definition of related party, you cannot, while you may be a creditor, but you can't form a part of the Committee of Creditors. Operational creditors are not supposed to be part of Committee of Creditors. However, in absence of any financial creditor, operational creditors can become a part of Committee of Creditors if there are no financial creditors at all. One important aspect is that in certain cases, there are certain related financial creditors, which such as banks, financial institutions, which are regulated by the financial sector. They become related party because they have converted their debt to equity. Now, if that debt to equity has been converted, they may fall within the definition of related party, but they are banks who have done it because they're regulated by financial sector. So the IBC gives an exception to such related financial creditors to become a part of Committee of Creditors. That is an important fact. So if you're a bank or a financial institution who had given a debt and you've converted that debt to equity, and because of which you have technically become related party, you may still form a part of the Committee of Creditors because of this exception. We'll move on to the next slide, which talks about the voting threshold of the Committee of Creditors. All decisions of Committee of Creditors are to be taken by a vote of not less than 51% voting shares of the financial creditors. This excludes certain decisions where a 66% voting threshold is specifically required and should include the following. This is just an indicative list, but an important one. If there is an extension of CIRP beyond 180 days, if there's a question of appointment or replacement of a resolution professional for approval of a resolution plan, for liquidation of the corporate debtor, and for all actions under Section 28 of the code, such as raising interim finance, undertaking related party transactions, etc. We'll move on to the next slide. So this is what talks about what is the role and function of resolution professionals and the Committee of Creditors. After having gone through the CIRP process and having understood the role of resolution professionals and Committee of Creditors, it's also now important to touch upon the cross-border insolvency regime. Now, IBC currently has a minimal two-section cross-border insolvency framework, Section 234 and Section 235. Section 234 enables the government to enter into bilateral agreements with foreign states for cross-border insolvency cooperation. And Section 235 allows NCLT to send a letter of request to foreign courts authorities regarding assets or evidence abroad. These are the enabling sections. Details of cross-border insolvency regime has not yet come into force. There is a proposal by a committee, by the Insolvency Law Committee, to adopt the UNCITRAL model law, and that should be applicable to the Indian Insolvency Code, but that is still a proposal that is still not come into force. So how do we resolve the cross-border issues in terms of insolvency, especially when the assets of a corporate debtor are at different places, right? So therefore, in the interim, one has to look at the Jet Airways example. Now, Jet had parallel corporate insolvency resolution process in India and insolvency proceedings in Netherlands as well. And NCLT, which is the appellate tribunal, approved a cross-border insolvency protocol that treated India as the main proceedings and Dutch case as the non-main, with Dutch administrator attending the COC meeting as an observer and coordinating asset realization and information sharing with the Indian RP. So Jet Airways is a classic example of a court-led scheme or protocol as far as cross-border insolvency is concerned. But we anticipate that this is going to be more fleshed out in details and codified in times to come. Let's move on to the next slide and look at the other aspects of the presentation, which is, of course, the key consideration for investors. It is very important that when an investor is looking at the IBC and looking to acquire stressed assets under IBC, what are the key considerations which the investor should keep in mind? Due diligence, of course, is the primary factor. When an investor is looking at due diligence of the corporate debtor, it is basically supposed to look at and identify the financial liabilities, whether it's contentious, non-contentious, direct, indirect, or whether it is contingent liability. So identification of financial liability is very, very important, followed by tax losses. Now, a lot of investors, clients have asked us, why tax? I mean, we are looking at liabilities, we should look at financial liabilities, litigations, and other dues. Why tax? Tax losses. But tax losses are equally important. We have seen some deals being structured only to get benefit of the tax losses, because if the corporate debtor has tax losses and you have the ability to carry forward those tax losses, then you can reduce your tax liability substantially because of that post takeover and following a process of merger, reverse merger. Depends on how you structure your deal. So tax losses is again a very important aspect, not tax liability as such, but tax losses. Litigation again is another aspect which is very important, whether it's claim linked or non-claim linked. And why do we say it's claim versus non-claim? Because claim related litigation, for example, any bank or a financial institution has filed a litigation against the corporate debtor, that can be wiped out as a part of the resolution plan under the clean slate principle. But non-claim linked litigation, to give you an example, if it is a land acquisition related litigation, that will not get wiped out as a part of the insolvency process. So therefore, it's important to ascertain which litigation is claim linked and which is non-claim linked. There is always a lot of misconception in the market that under the IBC process, because bidders will get to draft a resolution plan and get a clean slate, all litigation will be wiped out. That may not be true. The next point, which from a diligence perspective, which the investors should consider, is identification of acts and offenses that would have to be protected by a particular section of IBC, especially under PMLA or ED cases, whether it will have any cascading effect on the new promoter, and what are the implications. So that needs to be very carefully looked into, and then followed by what are the government dues. Are there any secured operational creditors? Because normally you would say that, oh, operational creditors, I'm supposed to pay only the liquidation value. But if they're secured operational creditors, their liquidation value may jump up. So that's important. Are there any provident fund dues under the statute? So those under certain case laws are supposed to be paid completely and in full. So these sort of smaller issues needs to be highlighted in context of undertaking a diligence. The second part and the second key consideration for an investor when an investor is looking to acquire an asset under IBC is the request for resolution plan. Now, RFRP is a bid document which is given by the resolution professional or the COC to the bidders, which basically lays down the process of resolution plan submission, and it basically talks about certain specific clauses, and it also gives an evaluation matrix. So therefore, it's very important for bidders to carefully go through RFRP and understand what is the criteria on the basis of which their bids will be evaluated, and also to look at CIRP specific clauses like treatment of available cash. In some cases, the committee of creditors would want the available cash lying in the company to be a pass-through to them even after taking over of the by the bidder of the company. And also litigation proceeds. If there's a litigation because of which some proceeds are supposed to be incoming in the company, some creditors or the committee of creditors may ask for a pass-through of that to them as well. So these items needs to be looked into carefully, and then a commercial call may be taken. This also includes indemnity provision for a resolution professional, whether the bidders are comfortable giving indemnity for resolution professional or not, and that's something which needs to be looked into. Evaluation matrix, the last point on this slide, is again important. It basically talks about what is the criteria for evaluating a particular bid, and therefore it gives a great idea as to how to structure the bid so that you get maximum points in the evaluation matrix. Let's move on to the next slide, which basically talks about stitching up of the resolution plan. What is the structure of a resolution plan? So in terms of the structure, of course, the resolution plan should be divided into four broad parts. One is the financial proposal, which could include upfront or deferred payment, whatever the investor on the basis of a red flag report or its analysis would decide. They would have the flexibility to structure their bid, the financial proposal. What is the acquisition structure? This is very important. How do you wish to acquire the particular corporate data, whether you want to do it directly, whether you want to do it through an SPV, and that also is basically is determined on the basis of what is the most tax efficient way of doing it. So tax optimization is a basic criteria for an acquisition structure. Third is how do you address the due diligence findings? Now, the benefit of a resolution plan is that you can, as a part of the resolution plan or your bid, address the due diligence findings or the red flags in a form of reliefs which you can ask from the court. If you think a particular item has cropped up during diligence, you can make a chapter on reliefs and concessions to be granted by NCLT and then ask for that relief. NCLT may, at its discretion, may either allow those reliefs or may not, but you have the right to ask. You can also put certain assumptions and effects of the plan in the plan itself, which will further protect you and ring fence the investors from future liability. And also, importantly, follow the mandatory provisions of IBC and CIRP regulations, which are a must for any resolution professional to then pass the plan to COC for its consideration. One example is that the law provides that you have to give LV, which is liquidation value, to operational creditors. So you have to do that to make sure that the plan is compliant. We'll move on to the next slide. After having discussed the structure of the plan, we are coming almost to the end of the presentation, which also talk about the case study, as I said before. Now, this case study will give you a quick, information on how these bigger insolvency cases fared out. These three cases represent they were a part of the dirty dozen first 12 biggest insolvency cases which RBI had referred under IBC, and let's look at how they fared. When we talk about JP Infratech Limited, the admitted claim of JP Infratech Limited was roughly USD 2.71 billion. The resolution plan which was received was USD 1.23 billion, and also the plan also envisaged delivery of constructed flats to real estate allottees because it had many home buyers. CIRP was admitted in 2017 August, and the plan was approved in March 2023. So it took quite a lot of time for the plan to be approved. The implementation of this particular plan is still ongoing. JP Infratech did face a lot of challenges. It was a complicated asset in terms of land compensation, tax demand, and regulatory approvals. So JP was one example. Moving on to Bhushan Power and Steel, one of the largest insolvency cases in India, with admitted claim of USD 5.25 billion, while the resolution plan gave a value of USD 2.19 billion. The CIRP was admitted in July 2017, and the plan was approved by NCLT in Feb 2020, which is, given the size of the asset, was relatively quicker. Surprisingly, the Supreme Court rejected the plan post-implementation in May 2025, but then the order of the Honorable Supreme Court was reviewed, and it upheld the resolution plan in September 2025. So this stands resolved. The third example case study is ABG Shipyard. Again, admitted claim of USD 3.03 billion, quite a large asset. CIRP was admitted in August 2017. No resolution plan was approved. Liquidation was ordered in April 2019, and the liquidation is ongoing. So this basically shows the different stages and the different outcomes these big cases achieved during this entire process. With this, we'll come to the end of the presentation and maybe move to the next slide where we can talk about certain key takeaways. So in terms of the key takeaway, if you recall the process, just to recap everything, there is a monetary threshold of INR 1 CR, USD 111,000. Financial operational creditors can initiate insolvency. The corporate debtor can itself initiate insolvency if the threshold is crossed. Once the company is admitted into insolvency, the resolution professional will take over, will invite claims, and constitute a committee of creditors, will again invite bids from prospective resolution applicants or bidders, will examine the bid from a compliance perspective, send that bid to COC for its commercial wisdom or for assessment of those bids. COC, while applying its commercial wisdom, can approve or disapprove the bid. If they approve the bid, it goes to NCLT for its final approval. If NCLT approves the plan or the bid, it becomes binding on all stakeholders, and then the plan is supposed to be implemented. Therefore, the key takeaway from this is that IBC now provides a central, predictable framework for resolving corporate distress in India, with a clear role for NCLT, COC, and resolution applicants, which are the bidders. And especially for investors who are acting as RAs, the code offers a legally robust route to acquire and revive stressed business with a transparent rule-bound process. Very, very clear. There are certain detailed amendments are also envisaged to further strengthen the code. There are many amendments, but I thought I'll just lay down two, three, which include introduction of a creditor-initiated insolvency resolution process, which is largely out-of-court process with limited role for NCLT. There would be enabling frameworks for group insolvency and cross-border insolvency to be fleshed out through rules made by the central government. And of course, the endeavor is to make the admission of insolvency simpler by removing subjectivity. So some amendments will also come into force, which will ensure that this happens. With this, I would like to end this part of the presentation. Thank you everyone for joining in and for the opportunity to present this. I'll be happy to answer any questions which you have, and back to Prasenjit.
Thank you, Siddharth. That was a really clear and well-structured presentation. We indeed have a number of questions from the audience, and I also have a few of my own that I would like you to comment on. Maybe I can start off with a broad lens before we zoom into some of the specifics. First, let's talk about, Siddharth, the overall performance of the IBC. In your assessment, how has the IBC performed so far? Has it met its objectives in practice?
Sure, Prasenjit. So yes, I would say that IBC has been a mixed bag. My view is that it has performed the role which it was supposed to be. It is not easy to have to get a new code in force and provide a time process and stick to that time. So by and large, while the resolution under code has gone beyond 330 days, I think the average time of resolution of any CIRP has been around 600 days, which is much more than the time envisaged under the code. But overall, if you look at the complexity of the jurisdiction and the purpose and so many bottlenecks, I think it has achieved its purpose, and it is a work in progress, I would say. The regulators are looking at IBC very carefully. They are listening to what the stakeholders want, and they're constantly trying to make amendments in IBC to make sure it works. So the answer is, in my view, yes, it has worked, but it still needs a lot of changes to make it even more efficient.
Well, that's Siddharth, a very helpful helicopter view. Let me now bring this a little closer to the ground and look at what slows the system down. So in your view, Siddharth, what are the principal reasons for delays in resolution under the IBC regime?
Sure. One of the principal reasons for delay is multiplicity of litigation. I know we have done away with multiple forums. We only have one forum, but that forum is more often than not flooded with a lot of litigations. And it is the job of the NCLT to listen, to provide hearing to every litigant. We have seen in our experience a lot of promoters filing litigation to basically derail the process at times. Some bona fide promoters don't do that, but some of them they do, and therefore that litigation has led to delay in implementation of the code and implementation of the plan. So that is one. Secondly, in my experience, we have also seen a lot of operational creditors filing cases and delaying the process because they are small-time creditors mostly who would want to file a case so that they can sometimes arm twist the corporate debtor to have a settlement. So that also, while it may not have a great impact in terms of the returns, but it may then slow down the process. So that these are the two main factors. Primarily, litigation is the main factor why IBC processes have not have been slowed down. And initially, when the insolvency code had come into force, because it was a new code, there were genuinely certain gaps in the code, right, which you only learn once you start seeing how the regime works. So therefore, in the initial days, there were a lot of litigation with respect to the interpretation of the provisions of the code, what is the purpose of the legislature, and so on and so forth. So that also led to delay, which is now being sorted out to a large extent.
Right, right. I think so.
Hope that
Siddharth,
answers. Yeah.
yeah, yeah. No, thank you. I think you've now in the first couple of questions explained the good, the bad, and the delayed. And since we have many international participants with us today, let me pick up a theme that's very close to their hearts. Uh, so, as a foreign lender, like how are the rights of foreign lenders treated under IBC? Are they in any way disadvantaged as compared to domestic lenders in India?
Yes. So the precise answer is no. So only because you are a foreign creditor, it does not mean that you're worse off as compared to domestic lenders. You have equal rights. If you have given a loan to a corporate debtor which is incorporated in India, you have every right to file or initiate an insolvency action, and become a part of the committee of creditors. If you look at the law, it does not at any point in time differentiates between a foreign creditor and a domestic creditor. You have equal rights. All it takes is what is your outstanding debt, and therefore your voting percentage will be calculated accordingly. We have seen in the past a lot of ECB lenders, external commercial borrowing lenders, foreign lenders who have given ECB play a very important role in terms of the IBC process, and they've taken lead also in terms of running the process because they have larger voting percentage. So yes, to answer that, Prasenjit, there's absolutely no disadvantage in terms of the rights which a foreign lenders can exercise under the insolvency code.
Right, right. That's, I'm sure, very reassuring, Siddharth, for the foreign investors. Level playing field is so, so important. And I think that's, I'm sure, very encouraging for them to hear. Let me now take maybe a step back and place the IBC in context with the older recovery toolkit. Uh, so, in your opinion, what is the single biggest advantage of IBC when we compare IBC with other recovery or enforcement statutes?
Sure. So my answer to that is slightly different. That I would not want to compare the Indian Insolvency Code with other recovery statutes, because as I said during a part of my presentation, that the purpose is very different. The purpose of the code is not to only provide recovery, but the purpose of the insolvency code is to rehabilitate the corporate debtor. And therefore, I do not see this as a straightforward comparison. Yes, the insolvency code does provide for mechanisms which ensures value maximization, but that's not the primary purpose. Just to give you an example, Prasenjit, look at the SARFAESI Act or look at the other statutes in India which provide for debt recovery. Their primary purpose is not to rehabilitate the company, but their primary purpose is to make sure that the enforcement process is eased out, it is quickened, and therefore the lenders can recover their money as soon as possible. IBC, on the other hand, talks about a proper mechanism where a resolution professional will take over, run it as a going concern, invite bids, rehabilitate so that the corporate debtor can be taken over while the company is running as a going concern. And in that process, also provide maximum returns to all the stakeholders. So therefore, both are different. IBC still, one can say, appears to be a preferred mode for a lot of stakeholders and lenders as opposed to some other statutes. And therefore, it's difficult to compare, but IBC has really changed the entire landscape, and most of the lenders today would prefer IBC. Or in terms of market practice, they may also want to settle the debt outside IBC and not enforce the security at all, if that answers your question.
No, it indeed does. And I think it clearly, Siddharth, brings out the edge which IBC affords. Uh, Let me now look at what the next evolution of this regime might look like. And in that context, if you can help our audience understand that, do you see a pre-pack or hybrid insolvency framework working in the Indian context? And how would you basically compare with offshore regimes, for instance, in the UK?
Sure. So pre-pack is already envisaged as a part of the insolvency code, though it is only applicable to smaller companies, which is MSMEs. Pre-pack has not yet come into force for larger companies. But the idea of the regulator, and at the last part of my presentation, in fact, in the last slide, I did also touch upon that a creditor-initiated insolvency resolution process is being envisaged as a part of the amendment. So both pre-pack and the CIIRP process also hint at a regime where the classic CIRP will be different, and this regime will be different. And in my view, the pre-pack and the CIRP has a very good future. It is a need of the hour, primarily because it does not take the promoter completely out. It is more of out of court. It is more of a debtor in control, debtor in possession, creditor in control model, in a sense that it's a hybrid model. So it's the moment the promoter is there in the company to make sure that he can run the company, he has an opportunity without losing the company to revive it. This will basically reduce the litigations and the bottlenecks in terms of implementation. And in terms of comparison, so to answer first part of the question, I believe that the pre-pack and process like CIIRP have a great future as far as India is concerned, and they will be used much more in future if both of them come into force fully. If you extend the pre-packaged insolvency process to larger corporates, I believe it will be used quite a lot. Same for CIIRP process, and therefore it will find a lot of success in future. And in terms of comparison, the UK regime of pre-pack is primarily voluntary in nature. It has very less to no court interference, right? Which is different from a pre-pack regime in India, where NCLT does oversee the process. The interference is minimal, but there is an NCLT angle to it, that you have to get the pre-pack scheme or initiation of pre-pack approved by NCLT, and then while the promoter is in control, it will submit a resolution plan, which will again have to be approved by NCLT. So it's a hybrid sort of model between UK and US. And therefore, I believe that this model, the current model which is envisaged of pre-pack, is very well suited to Indian conditions. So it's taken good things from UK and US and other jurisdictions and has come up with a model which will work best for India. So it's a bright future. To sort of sum it up, there's a bright future as far as hybrid insolvencies is concerned in terms of pre-pack or CIIRP.
Very interesting, Siddharth. I think very clearly there's a life beyond the classic CIRP. So that's, I'm sure, very, very heartening also for our audience members to take note of. Let me now put on the investor hat, and this is one question as M&A practitioner I was itching to ask you. So from a deal-making standpoint, and if you put an investor's perspective, what are the key advantages, if any, of acquiring assets through an IBC process as opposed to a solvent M&A acquisition?
Sure. So one of the basic difference between IBC and a solvent M&A is that in context of IBC, one, it's a court-approved process, right? And you, as a bidder, while you can do diligence in solvent M&A, you do diligence in a company which is undergoing IBC. The bidder has to draft a resolution plan, and that resolution plan can have a section on reliefs and concessions. So there are certain reliefs and concessions you can ask from the NCLT, which can be a part of your plan and which could be based out of your diligence findings. So that's one of the bigger benefits of taking over an asset under IBC. The second is that as per the law and as per the Honorable Supreme Court, which is the apex code of India, they have come up with judgments which clearly state that IBC would provide a clean slate principle to the bidders who are taking over. And what do we mean by clean slate is that as far as past financial liabilities are concerned, for which claim has been filed, if you settle those claims as a part of your resolution plan, whether somebody has filed a claim or not, then nobody can then come back to you to claim the balance amount, right? So you get a clean slate in terms of financial liability. And because you've clearly mentioned that in the plan, and that has been approved by NCLT, which then becomes binding on all stakeholders under Section 31. So that's, Prasenjit, if I can say so, it's a big advantage. I know you do a lot of solvent M&A matters, and in my experience, in solvent M&A, you still have to take the asset on as is where is basis, rely on indemnities. While you have more data, access to data is much more in solvent M&A. Access to data here in IBC process may be limited because some data may not be there, promoters are not cooperating. But you don't have to rely on indemnities. You can rely on what you mentioned in the resolution plan, get it blessed from NCLT, and then it becomes binding. So that's the basic difference between solvent M&A and a stressed M&A in context of IBC.
I think that's a great roadmap for the investors, Siddharth, what you just explained to understand the distinction between the two forms of acquisition. Let me drill down a little further on where those opportunities actually sit today in the Indian market today. So which sectors, I know you briefly touched upon actually during the presentation also, there's a specific question here. Which sectors currently offer the most attractive acquisition opportunities under the IBC from an investor's point of view, and what makes them compelling?
Sure. Yes, I did. You're right. I did briefly touched upon this in one of my slides, but just to give you more details on that, as I said, 37% of the IBC cases are in the manufacturing sector. So manufacturing sector is the main sector where we see a lot of activities in terms of IBC and as well as opportunities. Steel, within the manufacturing sector, steel is of course been at the forefront in terms of providing a lot of good returns to the stakeholders as well as to bidders who have taken over that. So, and why do we think that the manufacturing sector is providing a lot of returns under the insolvency code? Is because most of these are asset heavy, which would of course find a lot of takers. So that is one. Second sector where we have seen a lot of activity in the recent time is the real estate. Especially if you see the commercial real estate sector has seen a lot of good deal flow as far as stress M&A is concerned. Also because there is a huge land bank which is there, which provides a great value to any prospective bidder, prospective resolution applicant. So they do see a lot of value in that. The third sector is, though in my presentation it was stated as 2 to 3%, but we've seen a lot of action recently in the hotel industry as well. So many of these hotels have gone into insolvency, which has fined many takers. In fact, the bids for taking over these hotels have been shooting through the roof. So that's how much demand it's there in the market in terms of hotels undergoing insolvency. So these are the three sectors which I think have been very active in the recent past. Prasenjit.
Right. Thank you, Siddharth. I think so. Now we know where to look. And the next obvious question then, Siddharth, is how to price what we find. So how should a resolution applicant approach valuation where there are large legacy liabilities, regulatory uncertainties, or for that matter, pending litigations that could materially impact the business?
So in terms of pricing, look, if you're very skeptical about from an investor perspective, if there are a lot of red flags in a particular asset, then best is and you still want to bid there. Those red flags are not big enough for you to not bid, but if you want to bid and you think that this asset is a bit more risky, the bidders can structure their bid in terms of having an upfront payment, smaller upfront payment, and doing a deferred payment model. So that's one way the investors will want to structure their bid. Conditionalities in the plan is generally not allowed. If you make any plan conditional on fulfilling of certain conditions, they may treat it to be non-compliance. You can't put conditions as such, but you can defer the payment, the larger chunk to a later date, and then pay a smaller chunk upfront. And then in also those cases where the risk is more in terms of diligence, the bidders should also look at what are the tax losses in the company. If the company has good tax losses which can be carried forward, that could also be a key consideration for them to take over the company, because they may ultimately net it off and get benefit of tax, right? So that's another aspect which needs to be kept in mind when they're stitching up deals and when you're doing valuation of a particular company which is undergoing IBC process.
That's very helpful practical guidance, Siddharth. And just a quick, since you mentioned about deferment of purchase price, and we have a non-resident and international audience here. So if you try to defer your purchase price, Under Indian foreign exchange laws, you cannot really do that beyond a period of 18 months from date of your acquisition agreement and more than 25% of the acquisition price. So some nuts and bolts are
Yeah.
around deferment in the Indian foreign exchange laws. Uh, Now, since Siddharth, maybe one last question. I'm mindful of the time, but since timelines are always the elephant in the room, let me come back to that briefly. With all the ongoing reforms at the NCLT and a push toward digitization, do you expect meaningful improvement in resolution timelines over, let's say, next couple of years?
Absolutely, absolutely. In fact, the regulators' push has also always been towards digitization of the entire process. So, and with the amendments coming into force, hopefully, in the next few months, or we do specifically can't comment on the timeline, but these with IBC 2.0, which talks about a whole hog amendments in IBC to make it more efficient, the timelines are bound to improve. So regulators are very, very conscious of these timelines because that has been the major pain point in terms of making IBC 100% success. So yes, with digitization, with some amendments like making absolute clarity that the scope of the NCLT while determining an insolvency application is just to determine debt and default, and removing any sort of subjectivity from in terms of admission, those sort of changes and many other changes are being made are proposed to be made rather in the insolvency code to ensure that the the asset is resolved and the insolvency process is completed within time bound manner. So 100% yes, and the regulators are also on the same line and thinking on the same lines as far as making sure that everything is done within a time bound manner.
Thank you, Siddharth. So, quite optimistic you are. And on that optimistic note, I think let's kind of head towards the conclusion of this webinar. So, firstly, I will again start off, Siddharth, by thanking you for such a wonderful and informative session. I'm sure the audience would have absolutely found it worthwhile of their time. Thank you, and a big shout out to all our participants for joining us today and sparing their very, very valuable time. As a reminder, you will receive shortly after the webinar the presentation, the slide decks, the recording, and a brief summary note what was presented today. We'd also greatly, greatly appreciate your feedback. You will get a form and which will take barely less than a minute to complete. This will really help us ensure that these sessions which we bring to you continue to be useful and relevant for you. We look forward to welcoming you again soon at future programs under the Investing in India series. Thank you very much again and have a wonderful day, evening going well. Thank you.
Thank you, everyone. Thank you for joining.